My lord, may I be permitted to mention item number 160 of your lordship's list? My lord, this matter is a new motion stage, my lord, first time. My lord, pertains to warrant of arrest against three petitioners. That I am only praying for a stay of the warrant of arrest to surrender before the learned court below.
Wait, I will try to accommodate your matter at last.
I'm grateful.
First, let me start from the
My
regular
lord, as per your lordship's
matter.
My lord, may I come back at 4:15 then?
Yes.
Grateful.
My lord, 5টা অব্দি বসেন। 5টা অব্দি কোর্ট হয় এখানে।
My lord, grateful.
Yes.
পিটিশনের এদিকে আপনি
Yes, call the list.
এদিকে থাকুন, তোমার কখনো দুটো কোর্ট। Petitioner for me. My lord, item 1.
Yes.
My lord, I have a small request, my lord. Your lordship will not turn it down, my lord. Kindly passes it over, my lord. I am led by Mr. Mukherjee. My lord, Mr. Mukherjee is out of station. He's just joining online. But there is some connectivity issue, it seems, my lord. He'll be joining, my lord, soon. So kindly passes it over, my lord. We are just coming back by 3 o'clock. We will not embarrass your lordship further.
I am because I also
Only passes it
the
over.
matter.
I'm sorry.
Milord, I am appearing
already
for
said
the Milord, I am appearing for the OP number 2.
My lord, I am for the petitioner, so notice not issued, my lord. I'm just requesting for pass over only on behalf of
Milord,
Mr.
kindly take it up tomorrow, Milord. I am requesting, Milord, I am for the opposite party number 2. Kindly take it up tomorrow.
Pass over. He is not appearing, my lord, as yet. Notice not issued by your lordship.
No, doesn't matter. I am the complainant.
You-
I am the complainant. This is a large scale fraud which you have done.
No? Acha, yeah.
My lord, I'm just requesting for pass over. Mr. Mukherjee is joining.
No, take it up tomorrow. I am also not
Cancel.
in Calcutta. We did
Cancel.
not have notice. So, Milord, I'll be before your
Mr.
lordship.
Chaudhary, you must be aware of in a criminal revision, you don't have any prior notice.
No. Supreme Court has said I have a
The
locus.
Supreme Court has
because I'm
also
the
said that you
complainant.
cannot join online from a
Where is item
No,
number?
that is the first point we will argue. Don't worry.
Yes. What is in this matter?
But it's very difficult now.
No, what is difficult?
You are for the-
Your
Malad-
clients have
Get a
perpetrated
chance.
fraud.
You are for the
My lord, I am for the petitioner. I am led by Mr. Mukherjee. He was
and
here
you?
for the other side.
My complaint
You are OP here.
Yes.
Now, my lord, only request I have, Mr. Mukherjee is joining online. Kindly passes it
After
over.
admission, I can hear.
Mobilized, my lord. Kindly
Try-
passes it over.
Try to that.
Milord,
Just-
kindly takes it up tomorrow. We will
Pass it
also
over.
come to assist your lordship.
Pass it over once.
Most okay.
Wait, please, your lordship, my lord, I am appearing on behalf of the petitioner.
Yes. Huh? Take. Yes. What is this matter?
My lord, application filed by the state for cancellation of the, my lord, bail, of the petitioner's bail, my lord, that was
Yeah.
allowed, which is challenged before your lordship, my lord.
Uh,
Kindly see the orders. I received the bail. My lord, I made an application for relaxation of the bail conditions. That was also allowed. No adverse report filed by the police authorities, my lord. My lord, subsequently, because some other accused in the matter, they were absconding without going into the merits of these cases, that I am regularly appearing before the court and my appearance has been dispensed with, all the bail condition has been relaxed. My lord,
why the bill was rejected?
my lord, kindly see the
What is
impugned order, my lord.
where is the impugned order?
The certified
order
copy is
dated?
there, my lord.
Dated 30th August.
My lord, that is. Lord, kindly see the impugned order does not even array the grounds, my lord, on which the violation, on the basis of which violation, my bail has been cancelled, my lord. Only few bunch of judgments are quoted there, my lord. And it is nowhere the facts has been mentioned that because of this, my bail has been cancelled. With all the other accused who are not appearing and actually absconding, my lord.
Nothing is placed on record which can show that any substantial compliance of the condition by opposite party accused has imposed upon them at the time of granting bail.
Alright.
This is the observation.
My lord, I have annexed the compliance, my lord.
No.
Kindly see, my lord, page 21.
Hmm.
I have been regularly appearing before the officers, my lord, IO, and my lord, page 26 is the relaxation, my lord, which I prayed for and it was allowed. The petitioner name is my lord Saurabh Sivaji Sawant. At page 26, my lord, the relaxation has been allowed.
Did you place this order before the trial court?
My lord, we placed everything, my lord. It was part of the record. Placed everything without going into that, my lord. My bail application, my bail has been cancelled, my lord, because the other accused are absconding.
Yeah, interim bail was confirmed by this. order.
Confirmed, my lord.
Yes.
Confirmed, my lord, and the bail
But what about the conditions?
My lord, all the conditions were waived, my
Had
lord.
complied with the conditions imposed. Whether conditions were waived?
My lord, page 26, my lord.
No, nothing is about that. Yes.
My
Imposed
lord,
by
as
this
such,
court is
the
waived.
AI bail such and such, my lord, and the conditions are waived, my lord.
And who is the petitioner here?
My lord, the petitioner is Saurabh Sivaji Sawant, which is the
This is the same person.
same person, my lord. The petitioner before your lordship.
This is the order of 21st
October, my lord.
October. When the bail was granted?
Bail granted, my lord. Page 20, my lord.
Page
20, 20, my lord. The typed copy is also there, my lord.
What is the stage of investigation? Charge sheet submitted?
My lord, I've been instructed, the charge sheet has not been submitted yet. My lord.
Then accused number 5, 6, 7, and 8.
My lord.
The bail of all the accused persons has been cancelled.
All the accused person had been cancelled. My lord,
Then
the confusion was created, my lord, because the other accused person were not appearing before the learned trial court. So it was under the learned trial court was under the impression even I am not appearing.
come after service of notice, take down.
My lord, the stay of the order, my lord. My lord, I'll be arrested in the meantime.
Take down. Learned, yeah. Learned advocate for the petitioner challenge the order dated 30th August 2025 passed by Learned Chief Judge City Session Court at Calcutta in criminal miscase number 173 of 2024, thereby rejecting why are you making wrong submission here?
My lord,
Thereby rejecting the state's application for the cancellation of bail.
cancellation of bail. By
Rejected.
no, my lord, allowed, my lord.
Then what you are stating here in your application?
My lord, the application of the state was my lord, allowed, my lord.
Criminal miscase number 2, thereby rejecting the state's application
My lord, that
for cancellation of bail of the petitioner.
my lord, that I tender my apology, my lord. I'll make the necessary
No.
correction.
First you learn how to
My lord,
file your
Milord, kindly, Milord.
just the
petitioner-
opposite submission is here.
Milord, the petitioner, Milord, on record, Milord, the document says something else. Milord,
No, but you should be vigilant enough, na?
petitioner, Milord, I tender my
Time-
unconditional
Call
apology.
the
Milord, I tender my unconditional apology, Milord.
yeah. Well, yeah, look. The application is not filed properly. Leave is granted to learned advocate for the petitioner to file correct application. Yes.
Much obliged.
Item number 3, Milord, I am praying for a very short passover. I am led by Mr. Royan Bhattacharya
Yes.
in this matter, Milord. Very
Yes.
short passover.
Call the list. Call the list.
I am deeply obliged.
For the petitioner.
Yeah. What in this matter?
The petitioner is the husband, blood, the wife, opposite party number 2.
Compromise.
No, only 24 days was in law house. Wife was in law house, only 24 days. Marriage was solemnized in the year 2014.
Then
And thereafter, all on a sudden, when the petitioner was involved,
delay of 168 days.
he was not in the country. In the meantime, all on a sudden, file an application, wife file an application 125, and the proceedings is going to continue. Thereafter, the husband come back
After service.
and file the application 125, 4 and 5, that is pending, that is not considered till date, but the proceedings is going on. That is why
Yeah, take down. Crane 1 of 2025 is an application for condonation of delay. ওখানে বসে লিখতে পারো if you are feeling comfortable. An application for condonation of delay for filing the criminal revisional application for setting aside or quashing of the impugned order dated 26 December 2024 passed in Miss Case number 425 of 2024 pending before Judicial Magistrate 5th Court, Barakpur, 24 Pragna North, whereby he prays for condonation of delay of 168 days in filing this criminal revisional application. Petitioner is directed to come after service of this application of Crane 1 of 2025 upon the OPs. Let this matter appear and file affidavit of
Lordship, in the meantime, kindly stay the operation of the court.
Your revisional application has not yet been admitted. First of all, I have to condone the delay. Thereafter,
Kindly
admission,
consider the merit of
long
the case.
delay. Other side is required to be heard.
Lord, the certified copy obtained, but learned advocate did not.
Yeah.
Kindly give some protection. Warrant has been issued.
No. No protection. What protection you want?
Lord, the stay of the proceedings of warrant of arrest.
No. Still your
No, I know, only
petition has not
kindly
yet-
consider the brief.
let this matter appear. On 24th October 2025,
24.
before the bench having determination. I am fixing it on the first day on the reopening day. You come on that day.
But the proceedings is going on. That is the difficult. Well, short stay.
Without admission, how can I pass out?
The court has ample power to vacate the order.
Yes, court has ample power, but on your act is
No,
not
but
good.
during this puja vacation, he will.
Sorry, sir. Sorry. I'm not in position to grant you any relief. Yes.
Yes, but I'm for the petition. May it please you, lordships. The matter is very simple. It is the fight between CRPC and BNSS. Just come to the impugned order. It is
Fight
the fight
between?
between CRPC and BNSS.
What is your case?
My case is this: I have filed a discharge petition before the learned court bill. That is for the
Yes.
learned CBI.
What happened to your petition?
That has been rejected due to
You have challenged that order.
yes, due to since I have filed it under the provisions of laws as made in CRPC, on that very ground it has been rejected. According to the learned court below, it should have been filed under the provisions of laws as laid down in BNSS.
You file afresh under BNSS.
It has already been rejected due to the delay of 60 days. Because in BNSS, some delay is there. I'm pressing the just on the relevant two, three paragraphs I'm pressing. Just come to the headline. Special CBI BNSS came into force on and from 1st July 2024. Now my case is special CBI case number 1 of 2023. Then
Prior to
being
BNSS.
BNSS.
Yes.
Now, then I'm pressing the first two paragraphs. Today has been fixed for passing of order in connection with two petitions. Both
Of
dated
page number,
7
page number,
Lordship,
page number.
page that is the
Yes.
impugned order.
Yes, yes. Today has been fixed for
Uh,
passing. Yes.
Today has been fixed for passing of order in connection with the two petitions, both dated 7/7/2025, filed on behalf of two accused persons of this case, namely Raju Prasad and Govind Srivastava, praying for their discharge from the instant case. Raju Prasad is the petitioner in the instant case. Out of the total 8 accused persons, all of whom are on court bail, 3 accused persons, namely Govind Srivastava, Uttam Rawani, and Vishit Mukherjee, are present in court by filing Hajira. 5 accused persons, namely Raju Prasad, Mahesh Prasad, Jayantu Kanjiral, Tushar Kantidas, and Anjali Mistro, are absent by filing petitions under section 317 CRPC each. That's all. Then come to paragraph number, then sixth paragraph. Sixth paragraph. The learned advocate appearing on behalf of both the accused persons, petitioners, further submitted that it is the accused petitioner, namely Raju Prasad, who made a complaint with the state police regarding irregularities in respect of total 13 provident fund and pension files. On the basis of the said complaint, one criminal case was started at Asansol South PS, which ended in submission of charge sheet being number 49 of 2019, dated 27 to 2019 under section 409, 420, 120B IPC. Okay. Then the second page middle, at the time of hearing of the petitions under consideration, this court raised a point regarding the maintainability of these petitions in view of coming into force of Bharatiya Nagorik Suraksha Sanghita 2023 as BNSS with effect from 1/7/2024. Then come to the last paragraph. Now, if we peruse section 261 of BNSS, it says that any petition paying for discharge of an accused person may be preferred by him within a period of 60 days from the date of supply of copies of documents under section 230 BNSS. On perusal of the case record, it appears that the supply of copies of documents in the instant case was made on 27/6/2024. That is prior to the implementation of BNSS. Thus, the prescribed period of 60 days, as stated in section 261 of BNSS, has passed long time back. How on 27/6/2024, BNSS comes into the picture? 27/64. Yes. Petitioners even did not file the petitions paying for their discharge within 60 days from 1/7/2024. That is day on which BNSS came into force.
Yes.
Entire proceedings start. General principles law is this: when a case is registered, suppose Behala police station case number such and such, under section such and such, either of IPC, either of BNS,
Hmm.
That is should be taken into the point of consideration of the setting of motion of the case.
Hmm.
Now thereafter what happened? Thus, I got last
Then
operative
why
question.
didn't you file your discharge petition within time? What compelled you to file it after 60 days?
So that was there in the petition. It was explained, but but be that as it may, but I have prayed. I have prayed that guided the learned court below to condone the delay of 60 days and hear out my discharge petition on merit. And that apart, let there be a stay of operation of all further proceedings in this case.
What
So
further proceeding is there?
Had it been taken into
What
consideration,
further proceeding is there?
that it is now charge sheet has been submitted.
Then
Trial has just started, but trial of the petition has not yet been started. Trial of some other.
let the trial be started.
How let my discharge petition be disposed of first? Had it been taken into consideration under IPC itself, under CRPC, then there was no question of delay at all. But moment it comes under the point of BNSS, only then the question of delay arises. The BNSS doesn't have any role to play in this application.
That's why amendment has been
with CRPC
made in this application.
Because whole thing has been started well prior, well ahead of
for the
implementation of
petitioner.
Lordship.
Submits that his petition for discharge has been rejected
P2
by learned judge special CBI court Asansol.
Yes.
By the impugned order dated 5th August 2025. He submits that learned judge has rejected his application on the ground of filing this application after 60 days which as per section
The delay provision is there only in BNSS, but in PRPC there is no such delay. It can be filed at any time.
which is, as per section 262 bracket 1 of BNSS is barred. Referring the date of filing of complaint he submits that the provision of BNSS would not be applicable in this case as
Section 531 of BNSS, the repeal and savings clause are there. Section 531. It is clearly written that any matter pending prior to
not applicable
BNSS.
In this case as per
Section
section 531 of BNSS. 531 2 of BNSS. Yes, I have referred those sections. 531 bracket 2 A bracket A BNSS. learned trial judge has committed mistake by not considering his application under section his application under CRPC. Therefore, he prays for a direction upon the learned trial judge for hearing his application dated. What is the date of your application?
Application, it is annexure P2. Application dated is in P2. 7th, it is filed on 7th
7 July,
7th July 2025.
dated 7 July 2025. A phrase
Yes, 7th July 2025.
and dispose of his application on merit. Considering the innocuous nature of his prayer, direction of service upon OP is exempted. Considering accordingly, the learned trial judge is directed to consider where is your prayer.
Yes, it is in page 8, page 7 and 8.
To hear the matter on merit after condoning the delay in accordance with law.
In accordance with the provisions as laid down in CRPC.
CRPC is come under the law
Yes.
in accordance with law. Full stop. Till then, in accordance with law, as early as possible, the proceeding of what? Where is the trial number? Nothing is mentioned here.
Trial number that is in special CBI case number 1 of 2023.
Proceeding of a special CBI case number 1 of 2023. Be stayed till till 4th of the November. Parties are at liberty to place his matter before the trial court. Yes. Accordingly, the matter is disposed of. Yes. Kono crime nahi to. Yes.
The court will reopen on 27th, 24th.
Yes. So you go and mention your matter.
It is till 15th of November.
No. You go and learned trial judge will
That
hear.
court will remain closed till Kali Puja. That CBI court that will also remain closed. So
All court will reopen by 24th.
yes.
And
Give me one more week extension.
No, sir, sufficient,
It's
sufficient.
given that list.
No, no, yes, call the list.
ঠিক আছে।
My lord, I appear
ঠিক আছে।
for the petition.
Item number
Obliged to your
6, I beg to appear on behalf of the opposite party wife, my lord.
My lord, I kindly see this, but my lord, my lord, the petitioner before your lordship is
You
a
are?
husband. And the opposite party number 2 is a wife. But the opposite party 2 left more than 15 years, my lord. He is living, don't say. He is living with other person, my lord, as husband and wife.
You are for?
I am for the petitioner lordship husband. Oh.
And you are for the?
I'm for the opposite party wife, my lord. My lord, on the challenging the
before you-
maintenance order,
I
petitioner
pray
has filed one revisional
My
application.
lord, kindly hear me first. Hear me first, my lord.
My lord, let
I
the matter be
will
appeared together.
only hear you. You do not have local right to
My
make
lord.
submission.
My lord,
This is admission hearing.
My lord.
Let this matter be admitted first. Yes.
lordship. But previously, against the order, court below, my lord, a petitioner moved a revision application.
You are husband.
I am the husband.
Why
I am the husband, my lord.
why don't you comply the order of trial court? Misexecution case is pending against you.
My lord.
Why?
My lord, he was paying all the maintenance, my lord. Maintenance to the opposite party.
Where is the
regularly.
impugned order?
But some
Where is the
some
impugned order?
delayed
Where is the impugned order?
for payment of. And it is with the
ERWA. ERWA.
and the
ERWA.
my lord.
Warrant has been issued against you.
Yes.
And
Lordship.
you came here to
My lord,
get
I am
order
paying.
for the ST
I
of
have been
your
paying. I have been paying the areas payment has not been made, my lord. And
Come up.
not only this, my lord, I being a my lord, the employee of the state government, my lord, bus conductor under this state authority, my lord.
How much amount is outstanding? 3,11,200. Why don't you clear those
My lord,
pending amount?
kindly come to earlier order passed by the my lord additional session judge lordship, kindly come to page lordship.
I will not go to page other
Lordship.
page. I would be.
I only pray, my lord. I shall do anything, my lord. I shall do anything, my lord. Stay of the order, and matter will be.
Why should I stay? Why don't you pay?
I am the employee of the government, my lord. The warranted order issued, my lord, and date is fixed.
So
my
what?
lord.
You are employee of the government. Then
My lord, kindly see
are you above law?
and date is fixed, my lord. 28 my lord, October. Date is fixed, my lord. I will appear there. I will appear
Come
there.
after paying some amount to your wife, and I am fixing it for tomorrow.
My lord, only
Deeply
this one.
obliged.
No. Deeply
Come.
obliged. He is very much happy.
My lord,
My lord,
Why
very
not?
much happy.
Why
My lord,
not?
he is enjoying another person.
Tomorrow. Fix it.
Lordship, can you stay of the order?
Learned advocate
I will pay.
for
I
the
will pay.
pay and file a receipt of payment by tomorrow. Thereafter, I will hear you and
My lord,
will pass any order.
my lord, one thing I pray, my lord.
I will hear you tomorrow. Come after pay.
No, it is not possible tomorrow, my lord. My lord,
Then-
he is kind-hearted, my lord.
then-
My lord is kind-hearted, my lord.
Then
Kindly-
impugned order
kindly
could
keep-
not be.
Lordship,
It is
lordship,
upon you. You are government employee.
no, I will pay. Lordship, kindly impose any
No condition. Only one condition, you go and come after payment. Whatever amount you want. Whatever amount you want. I am not telling you to pay 3,11,000.
My lord, kindly.
Whatever amount.
I am paying the 5,000 rupees per month. There is your order.
No. I am not giving you any direction. but you come after payment of some amount
But
and
tomorrow,
file receipt thereof,
tomorrow is the last date for
I will
for
pass
holiday,
on
my
the
lord.
conditional order
My lord,
and you will
my lord, kindly I will pay.
you will pay, I will give pass order.
How it is possible? But tomorrow, tomorrow.
Come tomorrow, come tomorrow.
Now tomorrow it is not possible, lordship. Kindly consider this, my lord. I will pay.
Make it possible, sir.
Possible.
Make it possible.
Lordship is always
After
possible.
all, she is your wife.
He is leaving another person.
Will,
I have stated here.
that matter
And
would
keeping the two daughters and son with me.
be,
I am looking after.
if order go against your wife, then we will direct her to pay all the amount what you have.
Only this, my lord, this chutti period, my lord, kindly take holiday period.
No, sir, no, sir. No, sir. Come tomorrow. Come tomorrow.
My lord,
Come tomorrow.
All right, my learned friend helping me is subject to payment.
Come tomorrow. Come tomorrow.
Say subject to payment.
Come tomorrow.
No, come tomorrow. It is, my lord. I will go to today at 4:30, my lord.
Send your junior. Any of your junior will come.
My lord, junior. You, I have no junior, my lord. Lordship, kindly.
Yes.
My lord, one thing, my lord, pray subject to payment. Some possible
payment.
for me to.
Record.
এর মধ্যে ওই ফাইলটা রেখে দিয়েছেন এর মধ্যে লর্ডশিপ কাইন্ডলি কনসিডার দি
Heard learned advocate for the petitioner and peruse the material on the
দিচ্ছি
material on record. Petitioner is the husband of OP number 2. Execution of 125 proceeding is pending. The net advocate for the petitioner prays for a stay of impugned order dated 3rd September 2025, whereby a warrant of arrest against the petitioner had been issued by learned trial court. He submits that he is ready and willing to pay the maintenance amount
as per lordship's direction.
and the execution of warrant of arrest may be stayed on condition,
Sometimes
stringent condition.
possible for me.
Maintain quite, otherwise I will
Lord,
mention here that on a stringent condition. Don't tell anything. Yes,
I
on
am paid
condition.
for 5,000. Lordship, kindly give me some.
Let the impugned order be stayed till
2 weeks after vacation, lordship.
4th of the November or until further order, whichever is earlier, on the condition that he shall file the receipt for payment of what is the outstanding amount?
My lord,
What is the outstanding amount? Arrear of maintenance?
arrears, my lord, not calculated, my lord. So I pay something, my lord. I give the, my lord.
At 1,50,000 rupees.
It is not possible, my lord.
And file a receipt thereof. And file a receipt thereof. Let this matter appear under the heading of contested application before the Yeah. I am making it clear that in case of non-compliance of this order, the operation of stay would be vacated
Honorable,
automatically.
no, Lordship,
তারপরে let this matter আছে appear under the contested application.
my lord, only I,
Contested application.
my
That's
honest
it.
prayer, my lord, 50,000, my lord, I can, 50,000, my lord.
এই প্যারাগ্রাফ উপরে আসবে, making it clear that in the event petitioner failed to comply this order, the interim order would be vacated automatically. Let this matter appear before the bench having determination on seventh number.
Mention, Lordship.
On seventh number. Yes.
My lord, only my prayer is, my lord,
Yes.
by installment, 2 installment, my
No,
lord,
no.
only this prayer, my lord, by 2 installment.
No further prayer, sir.
Lordship.
Yes.
My lord, my appearance may be recorded.
No.
তোমার ওখানে কোনো হবে না।
For the petitioner, my lord, the petitioner was initially arrested and then thereafter he was granted bail by the learned SCJ. Now subsequently, my lord, the investigating officer files an application for cancellation of bail on the ground that there is a higher degree of offence has surfaced. Now, the cancellation of bail application was taken up and my bail was cancelled. Lord, the law is otherwise. Your lordship would kindly take the impugned order. Then, Lord, I'll be placing, Lord, the one of the judgment of the Honorable Supreme Court, which has really laid down the guideline with regard to, Lord, the cancellation of bail and what would be the procedure if higher degree of offences are, Lord, added. Your lordship would kindly take the impugned order, Lord. Your lord.
Why your bail has been cancelled? What is the ground?
Since, Lord, the higher degree of offence has been alleged, your
No.
lordship would kindly take, Lord,
No,
take-
such conduct of accused Govind Yadav clearly
No, Lord.
goes to show that he has misused the liberty of bail.
It cannot be. Your lordship would kindly take
This is the observation of trial court.
observation because of the reason there is a catch. Lord, your lordship would kindly take page 20 for a second. 20 is the order of bail. Lord, the girl had a relationship with the petitioner. They eloped. She voluntarily came back. Her 164 statement was recorded.
No, learned
said-
trial judge has applied his mind and
No, from
passed his order
Lord, from ACGM court.
by giving a sufficient reason.
No, Lord, your lordship
What
would-
wrong in this order?
Lord, the wrong is, Lord, the law says in that way, Lord, my bail cannot be cancelled. But I'm relying on a judgment of the Honorable Supreme Court reported in, Lord, 2000.
First you come to fact.
Lord, I'll just come. That is the reason, Lord, your lordship would kindly take page 20 for a second.
Page,
20 is my bail order.
page,
20.
where is the page 20? No page edition is there.
Immediately after, Lord, the affidavit page.
Yes.
Lord, that's the bail order. Lord, the learned magistrate records, your lordship would kindly take, Lord, the second paragraph. The APP raises objection of such prayer. The CD is not produced. In this context, I do concede that the learned advocate for the accused person, while submitting that the bail is a rule such and such, it is tried law that the personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is constitutional guarantee. Thus, such a right cannot be taken away due to non-production of case diary, as the same cannot be solitary ground for rejection of the bail. Now, Lord, then next paragraph meticulously introspected the case record and the materials available therein. From the case record, it is axiomatic that the allegations of section 137 to 140 subsection 3 of BNS has been attributed against the accused persons. All the sections under the section accused has been indicated are triable by this court, magistrate court. Besides, the statement of the victim recorded under section 183 BNS does not point towards the culpability of the accused persons. So, my lord, the 164 statement was initial,
Then-
initial. Then, my lord, the honorable
Come to the point.
the honorable
Come to the point.
now, my lord, then, my lord, the bail was granted.
Bail was granted, condition
petitioner
was imposed.
Considering, my lord, the statement under section 183. Now,
Yes.
my lord, at that, now later on, the kindly come, my lord, the next order.
Yes.
Now, my lord, the next order is order dated 4/6/2025.
Yes, yes.
Where the investigating officer, my lord, filed an application praying for adding section 6 of the POCSO Act,
Yes.
that before the learned magistrate.
Hmm.
After recording a second 164 statement, your lordship would kindly see the order, my lord.
Yes, 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 yes.
Your lordship has seen, my lord.
Yes.
Then, my lord, the next order is the impugned order 4
One line, my lord, one line. Lordship is one line. Otherwise, I will not have said that. My lord, it is one line. Para 23, one line.
Then let me hear you first.
No, my lord, let
Abbreviated.
my learned
Application কোথায় আছে?
let my learned senior friend.
Where is the application? Only documents are there.
Well, this is the application.
Where?
দিন বার করে দিচ্ছি তাহলে একবার তাও বার করে দিই এই এত আসলে মোটা হয়ে যায় না আমাদের আগে এগুলো এইটাকে আসলে প্রথমে সার্টিফাইড কপি দেওয়া মাইলর ঠিকই বলেছেন এখন এই সার্টিফাইড কপি প্রথমে দিতে বলে আর সব করে দিয়েছে
তুই কি বলবি না আমি বলবো
না তারপরে এখন
Very good. My lord, the issue is whether for breach, purported breach of a contract between two companies, non-executive directors can be hauled up. This is the simple issue. My lord, if we my lord, we have annexed, we have handed over a.
What is the impugned order or
No,
proceeding?
this is the, we have come up against the proceeding itself.
Proceeding.
My lord, this is the supplementary affidavit. Kindly see pages. Page 6.
You have praying for quashing.
Yes, my lord. At this
Why?
stage, I
What
will
is the
only,
ground?
only pray for admission.
What is the
That
ground?
the first ground is that I am not a executive director of the company. I am a non-executive director of the company. In proof of that, I would only take your lordship first to
You are CA. Are
No,
you CA?
No, non-executive director. I am not in the executive capacity. I am not involved in the day-to-day affairs of the
Okay.
company. What is the case? The case is that the de facto complainant is a company which provides loans to different parties. I am supposed to only forward the applications, fill up the applications and forward it to them. They are dissatisfied because there is NPS which happened. And therefore, they have invoked, there is an arbitration proceeding between the parties. An award is passed. We have challenged by a retired Honorable High
So
Court judge.
you had some role in entire proceeding.
Nothing alleged in the FIR.
No.
Nothing alleged.
This is
Kindly
after-
see page 6 first. My lord, supplementary affidavit. The supplementary one, my lord, with the small thin one. Kindly forgets about the thick one.
Yes, yes.
The thin one. Page 7, your lordship sees. না না জজ সাহেব অন্যটা দেখতেন বোধহয় বড়টা ছোট yes
Yes. Page 7.
Page 7 kindly sees Rajiv Maliwal.
Yes.
Rajiv Maliwal and
What is this document?
well, this is the DIR 12 appointment. This is
DIR 12.
These are public documents. Rajiv Maliwal, page 7. Then kindly sees Roman 9 designation, additional director, and category is professional. And then 12 is non-executive director, page 7. Then 34.
Second petition.
Rajiv Maliwal is petitioner number 1 before your lordship. Is a professional director and a non-executive director. Then kindly see page 34.
Page 34.
34 of that. Is petitioner number 2, Davesh Manacha.
Yes.
Again, additional director, professional and non-executive director. 9, 11 and 12. Page 34. Your lordship has got
Yes,
that?
yes, I am there.
Yes. And the petitioner number 3, page 51. Tanimira Koleva.
What you intend to show?
That these persons are non-executive directors.
So whether non-executive directors are exempted?
No, all I say is that they are not involved in the day-to-day affairs of the company.
But you are director.
Director. So policy. Here is a case.
Some role. How can you deny that you do not have any role?
I have a role in the policy decision, my lord.
I have a role in the
Those are
policy.
the question of merit and that would be decided later.
Yes. Now, with regard to
At
the
this
merit,
stage, these questions are not relevant.
kindly seize the FIR.
Where is the FIR?
FIR is from page 50, but kindly seize their prayer. They themselves do not know. In a page 30.
Page 50 is FIR.
Well,
Page 50 is FIR, not eligible.
No, certified copy.
well, the certified copy at the end.
This one.
At the end,
End,
the
my lord.
the original. Your lordship is right, my lord, which is why we have given
Yeah.
the original. Absolutely at the end of the brief. My lord.
Why so bulky?
My lord, yes, my lord, extremely. Because they have all started the civil things.
This is also not very clear. Huh? This one.
No, this is the formal. But your lot, it's a 156.3 application. After that, in a page 30.
Yes.
In a page 30, my lord, at the top, your lordship will get the page number, page 30.
Magistrate ACMM. Yes.
Well, kindly seize the prayer.
Suman Kumar.
Well, may I find it out for your lordship?
No, no.
Yes, yes.
I am there. I am there. So bulky, yes, prayer. In view of the aforesaid submission.
Yes, yes. Kindly seize. Kindly seize. How is
Direct the
A?
concerned police authority to
How is A and B maintainable even? A is direct the concerned police authorities. B is take cognizance of the offense. C is summon, try and punish.
Yeah.
And then D is again investigate. The next page. And nowhere in this complaint.
This is the defect of counsel. On Preeti Chaudhary, perhaps.
Court should have returned it. How could it have passed an order? And another thing I'll show, well, they say kindly takes up in a page 13.
30.
1-3. Your lordship was at 30. Kindly sees 1-3.
Yes.
Kindly sees details of fraud cases, borrowers. Now they say smart MK World Trade. In this case, learned magistrate has already directed for lodging of FIR and is under investigation.
What is this matter?
Well, what has happened? The matter is there is an agreement. I am supposed to get clients for them. If any person approaches me, I am supposed to fill up the form on the behalf of the applicant, thereafter forward it to them. They will thereafter do the final KYC checkup and thereafter disburse loans. Loan.
You are financial institution.
No, they are. They are supposed to do the KYC and thereafter issue the.
Then what is your role?
My role is only
money-wise financial services.
Source the thing.
And
that's money-wise is there.
You are
Coin
tribe technology.
Yes.
Then what is your role?
My role is to, if anyone approaches me for the finances, I am supposed to.
Why someone approach you?
Malad?
Why someone approach you?
Because I'm in the website. I'm a website person. So
for recommendation of any application.
Yes.
To money-wise financial services.
They are supposed to do thereafter the final KYC, and if they are satisfied, then they will disburse it in favor of the borrower.
So duty of KYC, role of KYC was interested upon you.
No, on the de facto complainant. On money-wise. We would arrange clients only. ওই জায়গাটা দেখিয়ে দাও না
So your role is only to arrange clients for
That your
money-wise financial services.
yes, that your lordship will get at 213. Page 213 we have annexed.
Yes.
Not the that's the duty
Agreement,
of
copy
tribe.
of agreement.
My lord,
Copy of agreement.
agreement,
213.
yes. What is my role? Role of coin tribe. And even I am a non-executive director. My company had invested in coin tribe. We are nominees.
197,
I'll show to your lordship that.
197, 6.5.
Huh?
197.
Of target customer for various financial.
Yes, that's all.
So your role is not confined to money wise.
Yes. Now
For other institutions, you are providing this service.
Yes.
Other institutions.
And there is now a arbitration award which is undergoing, which has been
Arbitration
challenged
award for?
in respect of this issue before a retired High Court judge.
Who referred the matter to?
Well, we were the claimants. They had filed a counterclaim.
Yes.
And that was decided. But kindly seize 197 for a moment.
So matter is civil in nature.
Primarily, they say it's a criminal, obviously. But kindly seize
what is the element of 420? Is there any?
My lord, they say that we have not done the proper background check. It's not my duty, it's his duty. Kindly seize page 197.
Yes.
Page 197, 6.5. It is the responsibility of
Let me admit this.
If you oblige.
May I? 2 minutes. 2 minutes.
No. Not now. Not now.
Mr. Dotto, you are not know very well. They will.
Yes, right. Let me pass order. Let me pass order.
Now, who's this?
I am not going to dispose of this
I'm not saying,
original application right now.
I will just show.
First of all, let me admit, give me direction to serve notice and you are petitioner. Serve notice
We'll
and
serve them.
copy of the revisional application.
Let it be after the vacation.
And on the date of hearing, your submission will be welcome.
There will be no interim order, my lord.
He will dictate.
But they will know because my lord, lordship
He will decide.
My lord, on their basis. My lord, what is their?
My lord, this is strange. When your lordship.
Let me admit first.
Yes. My lord, please only give me 2 minutes.
Just take your seat. Yes, take down. This is an application for quashing of proceeding.
No. সাথে কিছু করবো।
Where is the proceeding? Proceeding, quashing of FIR.
Yes.
Number 200 of 2021, dated August 6, 2021, under section 406, 415, 416, 420, 422, 467, 468, read with 120B and 34 of IPC, registered at the Bau Bazar Police Station. What is the PS case number?
Well, it's Bowbajar PS case number 200. Well, I know it's a sorry. I'm extremely sorry. It was drafted outside. That's why perhaps. Yes.
ওখানে
It would be Bowbajar PS case number 200.
Bau Bazar Police Station case number 200 of 2021. Yes. যেখানে FIR নাম্বার আছে ওকে বউবাজার পুলিশ স্টেশন কেস নাম্বার করছে
কিন্তু অনির্বাণ এখন জায়গায় দাঁড়িয়ে আছিস
for he learned advocate for the petitioner submits that they are additional director where is the notary and non-executive professional in the details of managing director in the which company you are referring to? In Quine Tribe Technologies Private Limited, as it appears from form number DIR 12 of the respective petitioners of the petitioner number 1, 2, and 3. As such, they had no role to no role attributed to the financial transaction which are the subject matter of challenge, which are the subject matter of the FIR. He further refer the defects in the prior part of the written complaint filed by the complainant OP2. You are OP2, whereupon the FIR, the instant proceeding was initiated the entire allegations are civil in nature and the matter is pending before the arbitral tribunal. Award is passed. And on self-same issue, self-same dispute, one award has been passed by the arbitral tribunal. Accordingly, he prays for quashing of the entire proceeding at the submission of learned advocate for the petitioner. Correct me if I wrong anywhere. Or if I leave something, then you may add. Yeah, having considered the submission of the learned advocate for the petitioner and the materials on record, I find prima facie, I find the arguable question is involved in this revisional application, which need to be determined after hearing. Accordingly, this revisional application is admitted. Learned advocate for the petitioner is directed to serve notice upon the OP number 1, the state of West Bengal, through the office of learned PP, and OP number 2, Money Wise Financial Services Private Limited, through a speed post with AD and file affidavit of service by the adjourned date. Anything? Limited estate. Limited estate. What? Estate? Oh, no. Investigation cannot be estate. Investigation cannot be estate. Just why are you? You take your seat. Why are you shouting? You do not have locus standi. No. Yes, sir, I heard you. No. Let me pass order. Don't make. I sought your assistance whenever I need. Yes. Service হয়ে গেল তারপরে let this matter appear. When should I fix it? This matter would not remain with me. It will be, yeah. Let this matter appear on 4th November 2025 before the court having proper having determination. In the meantime, no coercive step should be taken against the petitioner. The order, then you go for investigation. They will go. Who prevented you to conduct investigation? Then you call them. If they will not their petitions are directed to cooperate the investigating agency for the purpose of investigation of this matter. Anything more? Because yes. For the purpose of investigation, the interim order would vacate automatically after 4th of the November. No. You limited period. Or further order. You may make prayer before the. No. 4th November, by 4th November, you may mention. In the meantime, automatically vacated. Then I cannot pay for extension. Prior to 4, you can.
Your offer extension, vacating of this thing. Your offer
Yes.
So, and he permits us to pay for extension.
No, that order I cannot. Interim order is there, and you are at liberty to pray for extension. All the time you are at liberty.
It will stand automatically vacated, then I cannot pay for extension. So your lordship only indicates with the right to pay for extension and the obligatory vacation by the parties.
Okay, we will look. The interim order granted Yeah, the petitioners are at liberty to make an prayer for extension of interim order. Otherwise, the order would vacated automatically. আগে যে বলেছিলাম কেটে দাও আর একে দিও না না यस कॉल द लिस्ट एक एक मैटर आध घंटे नेबे तो हलो हलो Sorry. Yes, call the list. Call the list. Will not give you indulgence to pass over matters. Then yes. Then you are not cooperating. Why execution case is pending? After all, she is your wife. Why don't you pay?
The marriage is void. Firstly, she had a
Till the order of competent court would not be passed, your marriage is legal. You have to wait till the order of competent court. You go and
Niti has said that she doesn't have a child, but the order was passed on the premise that she was having a child.
Then
the order was passed on the premise that she was having a child.
that's why your CRR would be admitted. You come to the admission point now. Why are you?
I have one for appeal. Appeal is pending for the under section 20. In the meantime, what happened? She has started an execution.
Why this CRR?
CRR because in the execution case, a warrant has been issued.
Then what wrong with the order? You didn't comply the order of the court.
No.
What the court should do?
I have filed an appeal. My appeal has not been admitted.
Then why don't you appear before the learned executive court? Go and appear. Yes, you should be in custody. After marrying, you are roaming from pillar to post for declaration of your marriage void, and you are not paying a single pie to your wife.
That is not the case. The lady was silent. There are some other. I got to know that.
I am not on merit. I am not on merit. Go and appear before the trial court. What is the outstanding amount? You have to pay that amount to your wife. On that condition, no, you have to file within the time of stay, and on the condition of submission of receipt, your application should be entertained. No, appeal is a different thing. Appeal is not before me. Yes, take down. Learned advocate for the petitioner challenge the order dated 3rd March 2025 passed in complaint case 99 of 2023 by learned ACJM Basirhat North 24 Parganas under section 12 of Protection of Women from Domestic Violence Act 2005, read with section 8 19, 20, 22, 8, 19. 8 alda, 19 alda, 19, 19. Section 8, Section 19, Section 20, Section 22, Section 23 of the said Act whereby when the warrant was issued by SAT, where is the settle? Whereby, no,
22nd of August 2025. The certified copy.
issue fresh warrant of arrest. Earlier warrant of arrest was pending against you.
22nd of September 2025 was the date fixed on execution.
No, it appears from the order dated 13th June 2025 and 16th July 2025 that petitioner OP is thereby rejected. Issue warrant of arrest for ER of WA. The ER of WA was directed to pass.
That warrant is still pending. 22nd of September was the execution return date. Last time.
Whereby a direction to issue warrant of arrest against the petitioner and 22nd September 2025 was fixed for filing of execution report of the said warrant of arrest. He submit that he is ready and willing to pay the outstanding amount of 50,000 rupees, 55, 5,000 only. 55,700 to OP2 wife considering the submission of learned advocate. Yeah, considering his submission for the petitioner, let the execution of warrant of arrest issued by the impugned order be stayed till 4th November 2025 with a liberty to take a proper step before the learned executing court. First JM, additional judicial magistrate, first court at Basirhat. He is directed to pay the outstanding amount to OP number 2 and file a proper receipt to the executing court. Executing court shall entertain Executing court shall proceed to pass order as per law after submission of the proper receipt of payment of outstanding amount. In the event petitioner fail to comply the condition, the interim order, the interim stay on the operation of warrant of arrest should automatically be vacated. Accordingly, the CRR is disposed of. Go and enjoy vacation. Thank you. If petitioner fails to comply the yes.
Because she has alleged, that's my law is that petitioner he is enjoying an order of the learned district judge under the visitation of the child. The wife does not like the father to meet the child. So he's contemplating problems. Allegation, my lord, that the child was injured by the father on that particular day on 1st of March, on the day the visitation was scheduled. That particular day, law students had entered campus because of their visitation. Because the courtroom was packed, the visitation took place in the conduct. That's why there was no one to supervise. Usually the bench clerk or someone is there to supervise the visit. Taking advantage of that situation.
Child is living with mother and your husband. Yes. Yes. So what problem you have?
That I had injured the child by throwing a tennis soccer ball and by virtue of an injury, and she filed an application before the learned district judge. On 1st of March, she alleges this incident happened. On the 3rd, she made the complaint before the judge, seeking suspension of my visit. Based on the frivolous complaint, my visit was suspended temporarily, which has been again restored now.
Yes.
Immediately on 4th, my lord, she makes the order the police station, and that changed completely.
So impute proceeding are false and fabric.
And so now the visitation that was suspended now has been restored, and I have been brought an order. My lord,
Yes. Let me edit first. Thereafter, I will hear. You may take your seat.
I know they have brought against the petition that has been allowed, and that my lord, there's an adverse remark against the.
This matter is not before me. Right to visitation is not before me.
So why that? So the specific because that order.
Okay, let me admit this part.
Cheat. Page 19. Page 19 is.
Why are you referring those facts?
My lord.
Why are you referring?
My lord.
No.
Page 21.
Should I dispose of this? Stay of what? Okay. Okay. Let me pass. Let me pass out.
My friends, I have not been served with the notice, the mandatory notice under section 41. I have not been served that notice. And they have taken cognizance without that. My lord, that is a violation. That cannot be done. My lord sees here, my page.
Yeah, this issue you may raise before the.
No, my lord. That is the mandatory compliance. They have to comply with that.
Yes, madam. But you have to raise this question when your matter should be taken up for hearing. These are. Yes, I heard. Yes, I heard. Yeah, take them. Take them.
হয়েছে
No,
now lordship only one thing lordship next date is fixed on lordship 26th of November 2026 so lordship for lordship next date in this matter charge sheet that means for framing of charges so stay is not necessary kindly admit the revisional application direct them to serve a copy fixed any date next date is
Situation, she does not allow the father.
that has
both facts are different. Visitation right matter.
Visitation was allowed at the consent of the wife lordship. 25th of November is 26.
Submits.
By that time, the
question-
hearing will be concluded.
Proceeding.
Otherwise, they will extend the interim order for time to time.
My lord.
It's not necessary. They have
Take your seat.
they have taken the bail, and next date is 2026.
Submits for the questioning of. Allow me to pass order.
My lord, kindly grants me stay at least.
Allow me to pass order. Yes. For questioning of the proceeding arising out of Bardhaman Police Station case number 237 of 2025, charge sheet number 433 of 2025, presently pending before the learned Judicial Magistrate 5th Court, Judicial Magistrate 5th Court at Bardhaman.
1086 of 2025.
Yes. As it's the continuation of as its continuance will constitute an abuse of the process of court, alleging that abuse of the process of court, alleging that criminal complaint is motivated by matrimonial vindictiveness to terminate the petitioner's visitation rights with his minor child, Shaunak Chakravarti. She points towards a significant and unexplained material discrepancies between the facts narrated by de facto complainant in her formal application before the learned district judge on 3rd March 2025 and the subsequent contents of the FIR dated 4th March 2025 suggesting the possibility of embellishment to initiate a criminal case. The case of prosecution rests substantially on the statement of father of OP number 2
OP number 2 is the mother.
Pritharth Chakravarti.
Prithartha.
Oh. No, Prithartha is the male.
Why not Prithartha?
De facto complainant, wife of Subhadeep.
Yes,
Yes,
ma'am.
yes.
Prithartha is a female. Prithartha is the female. She's the wife.
Of OP2. Huh.
OP1.
And the application for and her statement recorded under section 161 of BNSS, who had simultaneously filed the application for suspension of visitation, raising a reasonable suspicion. Visitation, raising a reasonable suspicion concerning the interested nature of the testimonies. The doctor's opinion annexed to the petition records the injury to the child as simple, which must be examined in the context of gravity of the allegations. In the light of these submissions, particularly the element of material contradictions in the documents, this court finds the petitioner has made out a prima facie case for arguable relief, necessitating the detailed scrutiny of the records, accordingly, the application is admitted for hearing. The learned advocate for the petitioner is directed to serve notice along with copy of this revisal application to OP number 1 estate through the office of learned PP and OP number 2 through a speed post with AD and file affidavit of service by the adjourned date. The prayer of petitioner to stay all further proceedings of Bardhaman Police Station, case number 237 of 2025, dated 4th March 2025, pending before learned James 5th Court at Bardhaman. B estate.
Lordship, kindly consider the next date is Lordship 26 November, after 1 year. What is the purpose to stay, Lordship? On the next date, Lordship, it will be, Lordship, hard. On the next date, Lordship, it can be hard, Lordship. Kindly consider, Lordship. They are on
interim stay.
They are on bail. They are on bail, Lordship. Charge sheet submitted, Lordship. What is the purpose to stay the proceedings?
Both of you appear before the court and finish the hearing of
liberty to court for stay, Lordship, on the next occasion.
Yes.
If Lordship,
next day come prepare and dispose of this matter.
Lordship, kindly consider,
Yes.
if the order is stayed, Lordship, it will be extended time to time by day.
Be stayed till 4th November.
And prayed for warrant of arrest.
Yes, notice was served under 94. Yes.
I'm giving direction.
And there was sufficient elements in the lordship charge sheet for injury report was there.
2025. The matter will appear before the or until further order, whichever is earlier. The matter will appear before the bench having appropriate determination. Before the bench having appropriate determination. Having determination on 29th October. However, petitioner is directed to cooperate the trial court in the hearing of the proceeding.
And lordship kindly direct them to survey hand copy, lordship. Hand copy, lordship.
Yes. ओखाने जो OP number 2, you are
yes
in a year. Since OP number 2 is physically, OP number 2 is represented by learned advocate. Petitioner is directed to serve him a copy of this revisional application physically here and now. You
Here and now we have to make a photocopy.
By tomorrow.
Do you not have any extra copy?
2 copies we have, one for him, one for me. We will serve him.
So give him one copy.
Yes, we will.
And you may prepare.
We will comply with the order.
Yes.
Possibly.
Okay.
One subject to correction, one, I think my lord.
ওখানে যে আছে ওখানে স্পিড পোস্ট वाला বাদ দিয়ে দেবে স্পিড পোস্ট वाला যাবে হ্যাঁ সেটা তো পেয়ে গেছেন
Possibly one subject to correction, my lord, one error, 161 CRPC, not BNSS.
Oh.
Subject to correction.
161 CRPC. Yes, will. Sir, a copy. হ্যাঁ 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 তারপরে ওপি নাম্বার 2 রিপ্রেজেন্টেড হচ্ছে ওনাকে yes yes call the list.
Item number 10, my lord, I beg to appear for the petitioner. My lord, my learned junior is there, my lord, Mr. Dasgupta. My lord, a coordinate bench of this honorable court. My lord, I am the elderly parents of the accused in a case of 498-406.
Yes.
A coordinate bench of this honorable court passed an order on 11th of September 2025. Petitioner was there, the married sister-in-law. Your lordships kindly see the order. The next second page. Line number 5.
Yes.
The active role of the present petitioners with regard to the statement recorded under 161 of the Code of Criminal Procedure and 164 of the Code of Criminal Procedure fact does not reveal their involvement in the alleged offence at all. Only some allegations in the 161 and 164 against the husband. When 8 months delay, when incident took place in Bangalore, she was there, celebrated the birthday with the mother-in-law there. Then she left and lodged a FIR after 8 months. No explanation in Pornosi police station. When we are the elderly parents living in Ayodhya, Faizabad. When the mother was in ICU for heart attack. Recently discharged. The same relief we are praying. The order passed by Justice Ananda Bandyopadhyay staying the proceeding.
So she didn't get any active role of Soumya Kesarwani.
Yes.
So
Somo Kesarwani and other 2 married sisters.
Whether that observation
yes
would be applicable against Vishnu Kumar Kesarwani and Shikha Kesarwani, who are they?
They are the elderly parents of the accused. They stay in Ayodhya. Husband and wife stayed in, they are in IT professional, they stayed in Bangalore. Incident took place in Bangalore.
Then what is your
Then
prayer?
no involvement in 164, nothing against the mother-in-law. Only one thing, that mother-in-law over phone.
Your prayer is to quash the proceeding against the
Yes,
petitioner.
this is an admission stage. Give me this kind of protection only. Passed by Justice
What
Bandyopadhyay.
protection you want?
My lord, stay of the proceeding against the parents.
Which proceeding?
My lord, the 498 at 406.
What is the stage of proceeding before the court?
That is, charge sheet has been filed. CRR 23, that's order has been passed.
Charge framed?
Charge not framed, not yet framed.
Then let the charge be framed.
My lord, there is no, then the entire proceeding will be malicious. Unnecessary, I have to come from Ayodhya. I am an elderly parent.
Till indefinite period, proceeding should be stayed.
Not indefinite period. Lordship, kindly see the last order passed by.
This is the injury report the wife has suffered.
No,
Wife didn't suffer anything. She has
Yes, my
also
lord.
filed a
I know your
matrimonial
lordship's view,
proceeding.
my lord. I am not coming
after,
to the
after admission.
Absolutely,
After
my lord. I am just an officer of the court, my lord. Just one page. Because if my learned senior friend is making that submission 8 months delay, my lord, that is only for that purpose. Well, it's multiple
But
injuries.
she has no right of audience now. She has
At
no
the time
locus.
of hearing, I will certainly entertain.
I'm sure, my lord.
Yes, my lord.
Learned advocate for the petitioner prays for quashing of the proceeding. Prays for quashing of the proceeding of Pornosri Police Station case number 211 of 2024 dated 10th April 2024 under section 498A, 406, 307, 34, 506, 509 of the IPC, read with section 4 of the Dowry Prohibition Act 1961. Pending before the Court of Learned ACJM Alipur, South 24 Parganas. He submits that petitioners are father-in-law and mother-in-law of OP number 2, and there are no active role attributed by the petitioners in the alleged offense. Since OP number 1 and her husband, that is the son of petitioners, are IT professionals and they are residing at Bangalore in connection with their employment. The petitioners have been falsely implicated in this case, for the sake of harassment.
Paragraph 2 of the 11th September order passed by Justice Bandyopadhyay, fixing the matter on 8th of December. Let this matter be tagged with the same matter.
Those paragraphs cannot be referred. Yes. Having considered the submission of the learned advocate for the petitioner and peruse the material on record, this court find some arguable question remains to decide in this criminal revision. Accordingly, this revision is admitted. Who are your junior? Do you have copy of original application? Serve a copy to the learned report. Yeah. Petitioner is directed to serve a copy of this revisional application to OP number 1 estate through the office of the learned PP and file affidavit of service by the adjourned date. However, OP number 2 is represented by her learned advocate. Petitioner is directed to serve a copy of revisional application physically here and now. The prayer of petitioner to stay the proceeding in connection with Pornosri Police Station case number 2011 of 2024 dated 10th April 2024 charge sheet has been submitted.
Yes.
Here आगे लिखो. Learned advocate for the petitioner submits that charge sheet has been submitted and the case is pending before the court of learned ACJM Alipur South 24 Parganas for framing of charge. He prays for a stay of the
it has been transferred to
stay of the
ADJ.
proceeding.
7th court. Additional district judge 7th court Alipur. 7 fast track court.
Till
Transferred.
Transfer to
additional district judges court 7th court fast track Alipur. ADJ 7th fast track court.
The proceeding is presently pending before the ADJ FTC 7th court Alipur. FTC 7th court Alipur.
Alipur.
South 24. Let the he prays for a stay of the proceeding before the trial court for a limited period. Let the proceeding be stayed till 4th of the November or further order, whichever is earlier.
With a liberty to pray for extension.
Or further orders.
With a liberty to pray for an extension. Otherwise, the interim stay would be vacated automatically. Let this matter appear before the.
My lord, one very innocuous prayer, my lord, not stand in the way.
No.
Let them cooperate with the investigation. That's
on. Investigation is completed, sir.
Completed, charge sheet submitted.
Investigation completed, charge sheet submitted. So stay is only.
My lord, I have followed. My lord, I have followed. I have followed. I have followed.
Much obliged.
Before the bench having determination.
I'm grateful.
Yes.
Deeply obliged.
May I take back that bunch of my lord documents?
Yes, yes.
Wait. Okay.
Yes.
11 and 12, my lord, we can take together. One FIR I has filed, one FIR C has filed. My lord, both sides are appearing. CRAN application is filed in both applications. We are taking watching of both cases.
No, no, sir. 11 and
11 and 12. Now, my
12.
lord, may admit this, stay the proceeding and kindly call for record from the state with respect to the compromise in between.
Why are you? Compromise is there.
My lord, CRAN is. In
But
both
the signature of victim injured is not there.
in CRAN there.
No, no, no. Dilip's signature is not.
My lord is looking into page number 8 of CRAN application.
CRAN 1.
Jamuli Malik, page 9, sees the de facto complaint in CRAN 1, item 11. Can you page number 9?
You verify it once.
Madam.
Dilip Mullah. And where is 11? Item number 11?
11 your lordship is holding.
12 din Calcutta di. 12, 12. Yes. Signature of Dilip Mullah in item number 12 is not there.
Well, Dilip's signature is not necessary because in this case, Khokon is the de facto complainant and Uttara is the victim and Khokon is the accused.
But he suffered injury on his head. Attempt to murder allegations are made. So he is the necessary party.
My lord, may call for the report from the concerned police station.
Concerned police
That will be
station.
clear.
Report of?
Report from the state to confirm whatever your lordship is asking. That will be clear because we will.
Who is
not
for
be-
the state in this matter?
But we will serve until unless your lordship directs us. CRAN is filed. So lordship may direct for a report from the state and confirm whether the compromise entered into between the parties are in conformity with the victim and injured person.
Very well. Yeah.
That will
Take
serve
down.
purpose of everybody.
हाँ ना अलग करो दोनों में एक ही ऑर्डर होगा जाओ बस CRAN 1 of 2025 is an application is a compromise application filed jointly by the parties. Learned advocate for the petitioner is directed to serve its copy to the estate through the office of learned PP. Estate is directed to file a report in respect of compromise tomorrow. Do you think? Then after vacation, this matter will appear some. Let this matter appear on 7th November before the court having that revision. No, listed matter. Not yet admitted. Under the heading of listed matter, yes. Same. 11, 12, एक ही है. No. Not disposal. Direction was given. Direction has been given.
The report is called for.
Yes. Report is called for. Yes. होएगा चलिए. Why are you praying for questions, sir? What is CRAN 1? Joint compromise petition. Everyone put their signature, aggrieved, victim, injured. No, did you verify it? Both party sit together and verify one. Thereafter, we'll take up afterwards. Diyadin, verify everything. Same order, Diyadin. 11, 12, 30. Thank you. Stay cannot be granted. Stay cannot. That will appear before the court, having determination on 7th. So, no, unless a state would not appear, then you are on bill. Then I don't think. Yes, call the list. Call the list. Yes, what happened?
Person is right? I don't have opportunity for the degree. I would only come to section number 71 of the application.
What is his prayer?
His prayer is not passing.
Why? Why?
A revisional application was referred to on the same cause. Where passing was paid for.
What happened with that revisional application?
The operating part is page number 77.
77. Disposed of on merit or dismissed for it?
On merit.
Then he cannot.
So it had again family legal. It is not mental. I just have to demonstrate between lordship why it is not. So only come to item number 15.
Then this application is not in.
So, in view of the aforesaid discussion, order number 1, written such as that by which the court has framed.
By the way, what is his grievance? Why he is
Earlier, by this order, the order of the framing of charge was set aside on the pretext, that the discrepancies were there in the 161 statements and 161 statements. So the honorable court was under the impression that the charge frame was wrong in the sense POCSO sections were used. And
with direction to
continue the proceedings,
frame a charge afresh.
where we took a cognizance under sections 341, 353, 354.
With a direction to frame fresh charge.
That specifically was not there.
Even though he has a right to, and court is has a sufficient right to frame a charge afresh on the material available on the record. For that, direction and order of Honorable High Court is not required.
It is not required. And after that,
So,
they have subsequently preferred this application also for watching of the proceedings.
So I am giving direction to approach the trial court. However, this revisional application is not maintained. Yeah, take down. Petitioner is represented by. Give your name, sir. Give your appearance. Is represented by A, who was appointed, who has been appointed by this court to represent the petitioner as he had no capacity to engage advocate to represent his case. Your name is under the is in the panel of his name is in the panel of High Court Legal at Service. Who is required to be directed to regularize your appointment? Committee. Member Secretary of High Court Legal Services Committee is directed to regularize his appointment. Learned advocate for the petitioner submits that this is the second revisional application on self-same cause. Earlier one was disposed of on merit which attained finality by the judgment dated 10th September 2024 passed in CRR 3247 of 2022. As such, this revisional application is not maintainable and deserve to be dismissed. Accordingly, the revisional application is dismissed as infructuous. However, the petitioner is at liberty to take necessary steps before the learned trial court within 15th November, within 14th November, no 15th within 15th November 2025. Third Saturday. Accordingly, your dispose of ठीक है. Thank you. Thank you for your assistance. Yes. করুন পুজো আছে কিচ্ছু করার নাই অন্যকে একটা পাঠিয়ে দিন ছুটি আছে এদেরকে না রিলিভ দিলে তো আমারও তো মুখ শুকছে কি করা যায় কন্টিনিউয়াস বলতে যাচ্ছি यस Why are you paying for caching?
Paying for caching of the ground that complaint that was lost, that municipal application that was filed, that was filed after I had filed the section 9 application for it.
Case counter case and
I filed the restitution application. The moment she receives the summons to that application, she goes and files this domestic violence act proceeding after 2 years when she had supposedly on her own left her matrimonial with the two children. Now, so far as the orders are concerned, I have been saying that or the amount that has been directed by the learned trial.
Yes, take down. Learned advocate for the petitioner pays for quashing of C 2384 of 2022 corresponding to TR 789 of 2022 under section 2022 under section 12 read with section 23 of the Protection of Women from Domestic Violence Act 2005 pending before Landed Second Judicial Magistrate Alipur, South 20 Pargana, South 24 Pargana. As the proceeding was initiated falsely against them on the written complaint of your wife,
Yes.
your husband, my wife, of OP wife. There is case and counter case pending not required. Just I give some summary reference and thereafter. And the counter case pending between the parties and relationships are not good. Considering the submission of the learned counsel and material on record, I find the arguable question is involved in this regional application which need to be decided by hearing. Accordingly, this revisional application is admitted. बाद बाकी ये दिए दिन एक टाइम ओपी আছে. The notification for the petitioner is directed to serve notice upon OP by a speed post with সজ্জা থাকে আর তারপরে দেখুন and file affidavit of service वो सब एक ही टाइप का থাকবে. Stay the prayer of learned advocate for the petitioner to stay what is the stage of in whether charge sheet submitted. Stay. Where is the impugned order? Why warrant of arrest against you? Where is the impugned order? Without perusal of impugned order, I cannot pass.
Payment, I had made payment of that, I have received of that.
Any payment outstanding?
Then I have 67,000 approximately.
So you have to pay clear those outstanding amount. Learned advocate for the praise for praise the order dated 18th July 2025, whereby the warrant of arrest against him was issued. He submits that 65,000 rupees is 67,000 rupees is outstanding, and he is ready to pay the said amount. Accordingly, the impugned order is stayed till 4th of the November on the condition that petitioner should pay the should clear the outstanding amount and submit a receipt before the trial court. Otherwise, the order of stay would be vacated automatically. Petitioner is at liberty to take proper step before the trial court. The revisional application is disposed of accordingly. Oh, yes, sorry. Then what remains?
Because the proceeding was filed after I filed the restitution application. That debt.
Oh, let this matter appear. On 7th, no, on 31st October, before the court, before the bench having determination. Yes. Date has been impugned order dated. Yes. Just a minute, sir. Let me take up matter. Yes. How many matters are remain? Yes, yes. It is. How many of you are here for? Can I fix entire day tomorrow for residuary motion? That would be, I think, more convenient for. Tomorrow I will take only residuary writ motion and inform everyone. कल कहा जाएगा हम तो today I am taking only the criminal motion and will take up tomorrow, and if you will you all will help, then I think all 72 matter would be disposed of tomorrow by itself. That would be fine. You may inform a learned advocate for the state who will be here.
Item number 160 is fine.
Yes. What is that? Yes. Oh, you are, yes. What is there in your matter? আপনি চলে যান না, অন্য কাকে পাঠিয়ে দিন, আপনাকে লিখতেও সময় লাগবে। এই कोई अन्य एआर कोर्ट को बुला लीजिए, इनको तो लिखना भी होगा ना। यस यस
Injunction order of civil court. Violating that injunction order, I have discharged the property and figured and settled it. That is the gist of it. Our section 223 is there.
So how criminal section would be attracted?
That is why I am included.
Yes, take down, take down. Learned advocate for the petitioner submit. Where is the FIR? Submits that allegations in FIR is made. Just a minute, take to the written application. Did you mention it in your application? Paragraph number of your application. Come to your application. Property in possession quite
Paragraph number 8, my lord. Eight onward. Eight onward.
Learned advocate for the petitioner refer paragraph number. Okay, refer paragraph number 5, 6, 7. Eight and 9 of the revisional application to show that one incident was alleged by the OP number 2 happened (39)(4) happened after the order of trial court passed in title suit number 1300 of 2025 under order 39 rule 4 of the CPC. As a result, they allege that petitioners encroached their property and a dispute was cropped up. Prima facie, sufficient material is available on record to hear this revisional application. Accordingly, the revision is admitted. Baki serve notice on OP1 estate. Notice OP1 estate ache, OP2 affidavit of service. In the the limited stay, limited stay to the proceeding in BGR case number 42771 of 2025 What is the stage? What is the proceeding? What proceeding is there? What proceeding you are praying for stay?
The criminal proceeding, BGR case number 427.
What is the stage of proceeding?
Stage, my lord, so far as my lord, record says, my lord, stage of investigation.
Then should I stay investigation?
So, gossip measures be taken.
Are you cooperating? Okay, ये कर दे. Okay, कटे दिन. Investigating authority is directed to not to take any coercive step against the petitioner till 4th November. However, petitioners are directed to cooperate the investigating agency as and when required. Let the matter appear before the OIF on 31st. Or until further order, whichever is earlier, stay wala mein diye the. Yes. Yes, 19. Yes. Hmm. Since when your matter is pending? In the month of April this year. Then
No progress. At least while the supposed to be or
take down the present petition filed. Yeah, the petitioner prays for expeditious disposal of complaint case being CR number 148 of 2025, CR number 148 of 2025, filed under section 223 of BNSS, pending before learned JM, second court, Tamluk.
next date, the month of December.
Learned counsel for the petitioner submits that the complaint case, which was instituted under section 223 of the BNSS. What is this?
This is whether the petitioner supplied fish and other materials to the private restaurant, and against those consignment that was supplied, they are not going to pay.
BNSS has been pending for an inordinate period, primarily due to the failure of the trial court to take up the matter. That failure of the trial court to take up the matter expeditiously and the frequent grant of long and unnecessary adjournment. It is submitted that such delay is violative of the petitioner's fundamental right. It is submitted that such delay is violative of the petitioner's fundamental right to a speedy trial as enshrined under Article 21 of the Constitution of India. Having considered the submissions made and perusing the record, it is evident that the complaint case has remained pending for 5 months without substantial progress and the ground of long and unwarranted adjournment appear to be substantiated. The right to a speedy trial is a cornerstone of our judicial system, and the inordinate delay in the disposal of a complaint case is unacceptable. Accordingly, a learned magistrate, judicial magistrate, second court, Tamluk, is hereby directed to take up the proceeding in complaint case CR number 148 of 2025, 148 of 2025 on priority basis. The trial court shall fix the matter on consecutive working date for recording of evidence.
For SR and appeals. SR and appeals.
So at this stage, such type of direction is not required.
Still, for 5 months it is pending, the magistrate is not taking step.
The trial court shall take necessary endeavor. Okay, केटे दी. तो trial जने नहीं तो अभी trial बुझे अभी ये कोई. The trial court shall take necessary endeavor to expedite the progress in the pending case without granting unnecessary adjournment let this accordingly this revisional application is disposed of. যত হবে হবে কালকে দিয়ে দেবেন আর কি আর কই নেই ওখানে ওই বেট
एक आदमी 1.5 घंटा इसका तो हो गया ना
मतलब अब 3 घंटा से ज्यादा होगा तो क्या करेंगे अब लास्ट डेट है
कॉपी पेस्ट আছে कॉपी पेस्ट আছে
copy to sub. This is my only submission.
Item
35.
Right.
Waiting month.
On item 99 to 107 copy paste order, my lord.
99 to
107. Same order will be required. Law is settled. I will give judgment. Copy paste, my lord.
What is this matter?
As per section 217 and 1A, criminal proceeding is not maintainable when jurisdictional court has already decided the issue. But this order will clarify section 217. I have to stay in 7 matters. These are rest of the matters.
No, you have to take up those matters, na?
But proceeding is not maintainable. 99 to 107, same order. And this is the section matter.
Yes, take up few matters more.
Right.
Yeah. 30 for the list serially.
I don't know what 20.
Yeah, go on calling. 21, 22, 23,
24, I am for the petitioner lordship. Mr. Shubhadeep Chatterjee appearing in this matter. He is suffering from
Not today.
illness or
Yes.
high fever.
25.
Kindly after vacation.
25. My lord, I am for the petition in 25.
Yes. What is this?
I am, my lord, a licensed manufacturer of, my lord, Indian made foreign liquor. My lord, I was issued a permit, my lord, export permit from Madhya Pradesh Excise Department, my lord, to, my lord, transport 1,000, my lord, cases of, my lord,
Your matter will appear tomorrow. It will take some time.
yes, I'm great.
I am running short of time. That's why
I'm
I could not take such. Yeah. 26, 27, 28, 29, 30, 31. Yes. Yes.
Appearing for 31.
31.
My lord, appearing for 31.
My senior counsel.
What is this matter?
My lord, 31.
Brief.
My lord, the fact in this case is that previously one case of 498A was initiated against me. I happen to be the friend of the husband against whom they have initiated the case. I'm not a family member. I'm just a friend, not even a relative. Subsequently, in the initial case, the police have prayed for discharging me. They did not file any protest petition against it. But unfortunately, they filed this subsequent FIR against me and her husband, the private opposite party.
Yes. Then, what is your prayer here?
My lord, I'm praying for quashing of the proceedings.
Why you are praying? What is the reason?
My lord, I do not happen to be a relative or a family member of the husband of the private opposite party.
And you are implicated under section 498A.
498A previously.
Yeah.
That
Take
case
down.
ended up in
Take down.
FRT.
Take down. Learned advocate for the petitioner submits that petitioner is not a family member or relative of husband of OP number 2. Despite that, but what about 506 and 323?
My lord, I am working as a constable myself. I was
You
not
might
even
not
there at the
be,
place of. I
you might
take that
not
alibi.
charge-
My lord, I take that alibi. My lord, I can produce
Okay,
documents that on the date of the
okay,
occurrence,
okay,
I was
okay.
there on my
Let
duty.
pass order. Yeah, despite that, he has been impleaded for an offense under section 498A of the IPC, which is not maintainable in the eye of law. Heard and peruse the material on record. Peruse the material on record. I find sufficient. I find arguable question which need to be examined. Let this accordingly the CRR is admitted or hearing okay.
My lord, bring some kind of relief if it be stayed. If the further proceedings be stayed, my lord.
OP1 estate, OP2, OP1 estate, OP2 wife, service of someone, affidavit of service. Which proceeding is pending?
My lord, the subsequent proceedings that was drawn on the Paripur Women Police Station, PS case number 77, dated 11th of December 2024.
Charge sheet submitted.
My lord, charge sheet has been submitted.
Then
So far as the instruction I have is that charge sheet has been submitted, my lord.
Charge framed?
No, my lord. It is yet to be committed for trial.
Committed for trial. Then what proceedings should be stayed?
My lord, the next date has been fixed for serving of copy under section 207 of CRPC. Means that is the previous.
That proceeding should be should continue against the other accused persons. No,
No, I'm saying only on my respect if it be state, my lord, some kind of it.
The proceeding pending before the trial court against this petitioner, pending before the trial court against this petitioner, be stayed till 4th November 2025 or further order, whichever is earlier. Let this matter appear before the year on 31st October. Yes.
Much obliged, my lord. Much obliged.
Item number 32, item number 33.
Millard, item number 33, I'm appearing for the Millard respondent.
What is this matter? Respondent.
Respondent, Millard. So far as Millard, my knowledge is concerned, Millard, this is a maintenance proceeding, Millard.
Now you take up the list of the cases.
Lord, for the opposite party.
Why are you panting?
33, sorry. I'm just coming from the.
Your opposite party?
This 33.
33, so I am appearing for the respondent.
Sorry, I'm for the petition. Sorry, Your Lordship.
What is this matter? What is it?
Hearing before Millard, they have preferred a divisional application before the sessions court. That divisional application was dismissed by passing a recent order by the landed session. Now, Millard, again they have came up before this court by invoking.
Sir, are you for the respondent or the
That will take time. That will take time.
My lord, may I just indicate this? He's standing on the other side. Perhaps there's a confusion.
No,
You should come this side.
Here, Millard, they have not come.
Well,
That you are standing on that
It will
side.
take time.
There is a motion.
Do one thing. Do one thing.
Absolute case of gross
आपने
suppression by wife.
Do one thing.
My lord.
Give the details of your case and we'll take up these cases tomorrow.
Very well. Very well.
After criminal motions.
My lord, my matter is
No, Millard,
only
Now-
section 5.
Now AR code is
Only section 5, my lord.
Millard,
Only section
Millard, may I just make one?
Copy to
I
serve.
no.
Only copy to serve, my lord.
Millard, may I just make one
How should I
indulgence?
give dictation. No one is there to take dictation.
একটা সেকেন্ড
For the warrant.
But no one is there. I didn't pass time by sitting idly. Continuously, I am taking up matter 40 minutes past to the scheduled time. You sent someone.
Millard, may I just make one indulgence with regard to item number 33, Millard? Just now, Millard, that Lordship has pleased to take it up tomorrow. Millard, let them serve a